weigh in on this issue. Tell me why you won't weigh in on this issue.
Senator, I feel so strongly about ensuring that judges remain out of political debates. And this is something that is being debated. It is something that other nominees, Justice Barrett was asked about the same sort of thing and also declined to give her opinion. And I think that was the right way to handle this particular issue.
So you think Judge Barrett was right to dodge the question?
I think that each judge has to make a determination when asked about whether they would like to speak to issues. And I know that I'm not comfortable, in part because I'm so committed to making sure that there's confidence in me in terms of public confidence and my ability to stay in my lane, my ability to not speak to contentious political issues.
You have an opinion, though, don't you?
Senator, any opinion that I would have is not something that would ever come up in my work as a judge, something that I would ever rely on. This is a political issue for Congress.
But do you have an opinion, Judge?
Not a strongly held opinion, actually.
But you have an opinion.
I haven't really thought about it, but I hear the arguments on both sides, and I understand it to be a political issue.
A tense showdown breaks out as Senator John Kennedy goes head-to-head with Ketanji Jackson over her judicial ideology. This is Right Focus. If you stand with America First values and want honest courts, hit like and subscribe right now.
Thank you, Mr. Chairman. Judge, I have enjoyed listening to you today. I find you to be very intelligent and very articulate. I'm still a little uncertain about how you think, how you approach cases, deciding cases, and we'll talk about that in a moment. I'm not going to ask you, nor should I, how would you would decide a case. And I'm not going to ask you, nor should I, to tell me whether you think a particular precedent is a good precedent or not. So, but I am going to talk to you about the law. But first, you don't support efforts to delegitimize the United States Supreme Court, do you?
Senator, I have nothing but esteem for the United States Supreme Court, for my hopefully future colleagues on the court, and the work that the court does.
Can we agree that the calls to pack the court delegitimize the court?
Senator, it would not be appropriate for me, in my view, to comment on calls to pack the court, as you say, to increase the number, to do any structural changes. Those are policy determinations for Congress. What the consequences of those are policy considerations for Congress. I'm just looking forward to working with the brilliant people who are there at whatever size Congress decides if I'm confirmed.
Well, the calls to pack the court don't legitimize the court, do they?
Well, Senator, I think that would be for you to decide.
I'm asking your opinion.
Respectfully, Senator, I'm not in a position to give my opinion on issues that are policy issues concerning the court, and not something that a judge would have to consider or should consider, in my view.
Yeah, but you're a citizen.
Oh, I am.
and as best I can tell, a very good one. I don't understand why you won't weigh in on this issue. Tell me why you won't weigh in on this issue.
Senator, I feel so strongly about ensuring that judges remain out of political debates. And this is something that is being debated. It is something that other nominees, Justice Barrett was asked about the same sort of thing and also declined to give her opinion. And I think that was the right way to handle this particular issue.
So you think Judge Barrett was right to dodge the question?
I think that each judge has to make a determination when asked about whether they would like to speak to issues, and I know that I'm not comfortable, in part because I'm so committed to making sure that there's confidence in me in terms of public confidence and my ability to stay in my lane, my ability to not speak to contentious political issues.
You have an opinion, though, don't you?
Senator, any opinion that I would have is not something that would ever come up in my work as a judge, something that I would ever rely on. This is a political issue for Congress.
But do you have an opinion, Judge?
Not a strongly held opinion, actually.
But you have an opinion.
I haven't really thought about it, but I hear the arguments on both sides, and I understand it to be a political issue.
Now, Judge, you're very intelligent and you're very articulate, and I know you're very well informed. You're telling me you don't have an opinion about packing the United States Supreme Court.
Senator, I have opinions about a lot of things. I don't have an opinion that I think it appropriate to share. I work very hard to set aside my opinions when I'm thinking about cases, which is the work of a judge. And so this particular issue is one that is very contentious, as you say, one that's in the province of Congress, and one that I think it not appropriate for me to comment on.
I understand that. But I think it would tell us a lot about you if you would answer the question. I'm a little confused about your answer earlier. It's probably more my fault than yours. Do you have an opinion about whether these efforts to pack the United States Supreme Court delegitimize the court? Do you have an opinion?
Senator, I have an opinion about the efforts. It's not an opinion that I think is appropriate for me to share. And so therefore, I don't have anything further to add.
So you do have an opinion, but you don't want to share it. Is that?
I don't think it's appropriate for me as a nominee to comment on a political matter that is in the province of Congress.
Well, in deciding to join the United States Supreme Court, if you're affirmed, wouldn't it make a difference to you whether you're one of 9 or one of 28?
Would it make a difference?
That impacts the judiciary? That involves the judiciary?
Senator, it certainly involves the judiciary. I would be thrilled to be one of however many Congress thought it appropriate to put on the court.
Okay. So you'd be okay if it was 28?
If that's Congress's determination, yes. Congress makes political decisions like that.
Okay. A couple of my colleagues ask you about the Supreme Court overturning precedent. Now, it doesn't happen every other Thursday, but it's not, what's the word I'm searching for, Judge? It's not extraordinary that the Supreme Court overturns precedent, is it? I mean, it happens. I won't say a lot, but it's not once every 50 years. Am I correct?
You're correct that it's more frequent than once every 50 years, for sure. Yes.
And so it happens.
Yes.
And you talked earlier briefly about the different factors that the court considers
Yes.
in deciding. Give me a couple of those. Hit that another lick for me and just give me a couple.
Whether the decision is egregiously wrong, whether there's been reliance on the decision that is being revisited, whether the decision is workable or unworkable, the one that they're looking at, whether the facts are new facts have come to light, or the facts have the circumstances are such that there's now a new understanding of the prior facts, and whether the case law in the area has shifted.
And in fact, those are the factors that the Supreme Court listed 3 years ago in Janus, are they not?
Those are the factors. I don't have the Janus opinion in front of me, but those are the factors that the court uses when it determines.
Janus overruled, I think Senator Hirono talked about it. Janus overruled Abood,
Yes.
dealing with whether labor unions can require non-members to pay dues. Remember that case?
Yes.
Is the age of the case, a factor in whether the Supreme Court will overrule a precedent?
I think age relates to the reliance factor. I think the longer an opinion has been in effect, the court has considered that to be relevant to its determination of reliance.
But sometimes the court looks at it not just in terms of reliance, they look at it from the other side of the age issue, and that is that maybe facts and circumstances and science have changed. Do they not?
I believe that is part of the change circumstances factor.
So the Supreme Court is more likely to overturn a case, which would not be that extraordinary, if the precedent were 49 years old as opposed to 4.9 years old.
I'm sorry. Can you repeat the question? I'm just
Well, you said that the older the case is, one could make an argument that the reliance interest would be great. But you also said, I think, I don't mean to put words in your mouth, but the older the case is, the more facts and circumstances and science could have changed. So that would argue in favor of overruling it because of a change of circumstances. Did I get?
It might. These are all different circumstances that the court could consider under this multi-factor test.
Okay, but all things being equal, let's say decision's 49 years old versus 3 years old, like Janus. The older decision is more likely to be overturned, you think, based on your experience?
Oh, I don't know that I could make that prediction. I'm just saying that one of the factors, the reliance factor, the age of the opinion and how long people have been relying on it
Yes, ma'am.
can be relevant to, it is one of the factors that the court considers.
Right. Okay. Let me jump gears here. I took some notes. You talked earlier about how you decide cases. I'm going to kind of summarize this. You said you clear your mind of any bias. You read everything. You read the briefs and the record, and then you apply the law. That's your methodology. You said you're not an activist judge. You said, am I right?
Yes,
You said judges are not politicians,
that is true.
and judges should stay in their lane.
Yes, sir.
Tell me again what you mean by stay in your lane.
What I mean is that in our system of government, under the Constitution, we have a separation of powers, and each branch has their own sphere of responsibility. To say stay in your lane is the shorthand that I'm using for indicating that judges should not be policymakers, that those responsibilities are left to the elected branches, and that judges are to interpret the law, not make the law. And I use it to refer to the part of my methodology that is mindful of the constraints on judicial authority.
Okay. Well put. So let me ask you. We can go to the Constitution, let's say the Bill of Rights, to narrow the discussion, and read about our explicit rights. Religious freedom, our right not to be unreasonably searched or seized, freedom of speech, they're right there. That's why they call them explicit. But the court has ruled we have a bunch of unenumerated rights. Am I correct?
The court has determined there are certain personal rights related to individual autonomy that are implicit in the concept of ordered liberty or deeply rooted in our nation's history or tradition.
But they're unenumerated.
Yes.
Okay. Should these unenumerated rights that only Supreme Court justices can see, should they be decided by the people through their elected representatives or by the unelected federal judiciary?
Well, Senator, the Supreme Court has interpreted the 14th Amendment to have a substantive component, and I'm not in a position to critique the court in terms of its precedents. That is the precedent of the Supreme Court.
Right, right. Well, let me ask you this: what is a fundamental right?
The court has interpreted the 14th Amendment's due process clause to include a substantive component and not just a procedural component, meaning the 14th Amendment guarantees due process, and the court has interpreted it to mean that with respect to certain rights, individual rights concerning intimacy, certain things like the right to contraception, the right to child rearing. There was a case of the Supreme Court that talked about making decisions for children in terms of visitation with respect to conflicts with grandparents, marriage.
Right. I'm with you.
These sorts of rights, the court has found, are implicit in ordered liberty, as I said, or deeply rooted in our nation's history and tradition.
The right to assisted suicide, is that one of those enumerated or unenumerated rights?
I believe the court found that it was not.
Okay. Which body do you think is better able to make that decision, the Congress or the federal judiciary?
Well, Senator, the Supreme Court has interpreted the Constitution, and the Supreme Court has the authority under our constitutional system to interpret the law.
Right.
And they've made the determination that the Constitution includes those unenumerated rights.
Yeah, but here's the thing, Judge. Maybe a better example, it's a very hot topic today, the right of a transgender woman to compete in women's sports. Do you think Congress, the people ought to get to decide that through Congress, or the judge can just find it as an unenumerated right, a penumbra of the Constitution?
Well, Senator, that the topic that you raised is something that is, as you say, a hot topic today and
Yeah.
could certainly be litigated. So I'm not in a position to say more about whether or not it's actually one of the unenumerated rights
Well,
in the Constitution.
I don't want to ask you how you'd rule, but would you have any problem saying, okay, if that case that is litigated, saying this is a political question? Whoa, stop! I'm staying in my lane. Congress needs to decide this case. The people need to decide that through their elected representatives.
Well,
Would that be appropriate?
Well, respectfully, Senator, that is a decision. In other words, you say, I'm not asking you to decide it, but in every case, the determination about whether or not something is a political question or whether or not the court has or has not jurisdiction is an issue for judges, and so I'm not able to speak to it.
Okay. All right, well, here's the thing about the fundamental rights. That's why I asked you about the definition of them. These are unenumerated rights now. I'm not talking about right to free speech and freedom of religion. The court has said repeatedly that there is no test for a unenumerated fundamental right, that the determination has not been reduced to a formula. Am I right?
Well, they've given those standards in the cases in which they have been evaluated.
In some cases. Sometimes the court talks about these unenumerated fundamental rights have to be deeply rooted in the nation's history and traditions. Sometimes the court says, they change the language, these unenumerated rights, like the right to assisted suicide we talked about, it's a potential unenumerated right. The right has to be implicit in the concept of ordered liberty. But you've read Obergefell. In Obergefell, I think Justice Kennedy wrote that opinion. He didn't bite. In fact, he cited with approval Justice Harlan's dissent in Poe v. Ullman. And Justice Harlan said, look, there's no formula here. Justice Harlan always said, you have to go case by case. Can you understand why some Americans go, wait a minute, are justices, these are unenumerated rights, are justices interpreting the Constitution, or are they just deciding a right when they get 5 votes, and it's just a moral conviction?
Yes, Senator, I do understand.
Okay. Well, when you talk about judicial restraint, where does the restraint start with fundamental right? Let's take the 9th Amendment, okay? What's it say? I know you know because you talked about it earlier.
Well, it says that it indicates that there are rights that, the fact that there are some enumerated rights in the Constitution doesn't mean that there aren't others.
And how are we supposed to determine what others there are?
I think the Supreme Court has not found any others coming from that particular constitutional provision.
Could they?
I can't speak to that, Senator.
I mean, it's possible, right? If they get 5 votes, right?
Well, anytime the Supreme Court has 5 votes, then they have a majority for whatever opinion they determine.
Yeah. But do you think that would be a prudent course of action to start creating fundamental rights through the 9th Amendment, unenumerated now, without consulting Congress?
Senator, I can't speak to a hypothetical about whether or not it would be a prudent course of action for the Supreme Court to hold that there were other rights in the 9th Amendment. That's
Well, the reason I'm asking, Judge, is you've talked a lot today about judicial restraint. And that's kind of like being for children and prosperity. We're all for children and prosperity and judicial restraint. But the rubber meets the road when you get down to, well, what does that mean? What does that mean?
What it's meant for me, Senator, is what you've seen in my opinions, in the way that I've approached issues that have been before me, in my fidelity to the restraints that exist in the law in terms of the exercise of judicial authority. That adherence to precedent, for example, is something that I do, and even in cases, as you heard me discuss earlier, in which they're not binding precedents, I find that the court needs to take into consideration what has previously been determined, and not be a policymaker in my decisions.
Okay. Well, here's what's bothering me is too strong of a word. Sounds pejorative. Here's what I'm uncertain about. And please don't take this the wrong way. How do we know? I'm not saying you would do it, but how do we know that, since I can't seem to flesh out this judicial restraint and the limits of it for you, how do we know that if you get on the court, you won't say, well, you know, Congress can't get anything done, and there are all these issues that we need to address. And so I think the United States Supreme Court ought to create all these rights through the Ninth Amendment. What would you say to that if somebody made that allegation?
Well, Senator, I think that I have a record as a judge in terms of having been given responsibility, having looked at cases, having decided issues, and that my record demonstrates how I handle cases. I'm not in a position to hypothesize a circumstance in which a case appeared that raised a question about the recognition of an unenumerated right, and whether I would say under those circumstances that I couldn't find such a right because that's a hypothetical, because I decide cases and controversies that come before me, because I'm a nominee and I can't speak to hypothetical scenarios about how I might rule in the future with respect to cases.
Boy, the time goes fast. Let me ask you one other question.
Yes.
This business of having unenumerated rights through substantive due process, there's no textual basis for that. The court just started doing it, okay? I'm not asking you whether you think it was good or bad, because it's clear to me you don't want to share your thoughts on that, and I get it. I'd feel better if you would, but I get it. But don't you think the fact that our founders included a way to amend the Constitution is a testament to the fact that they were saying, here are your rights, we're writing them down. You can all go to the Bill of Rights and read them. And if you want more, we put in a way to amend the Constitution.
I do understand that argument, and there are people who argue that. The Supreme Court has determined that the Due Process Clause
Yes, ma'am.
includes a substantive component.
Okay.
And I understand the critiques of that view.
I'm going to try to get in two more. Boy, the time flies. When does life begin, in your opinion?
Senator, I don't know.
Ma'am?
I don't know.
Do you have
I
a
don't-
belief?
I have personal, religious, and otherwise beliefs that have nothing to do with the law in terms of when life begins.
Do you have a personal belief, though, about when life begins?
I have a religious view
Religious belief?
that I set aside when I am ruling on cases.
Okay. When does equal protection of the laws attach to a human being?
Well, Senator, I believe that the Supreme Court, actually, I actually don't know the answer to that question. I'm sorry. I don't.
Okay. All right. You're familiar with the warrant requirement, I know.
Yes.
Okay. What if Louisiana said, we don't want to follow the warrant requirement? Would that be legal?
Are you positing a statute of Louisiana that we're not following, or individual law?
Yeah, it's called a statute.
Well, Senator, I'm thinking about all of the potential legal arguments that could be made. I can't answer the hypothetical about whether or not it would be lawful or unlawful.
Can you think of an instance where a state could say, we're not going to follow the warrant requirement. We're going to write our own warrant requirement?
I've never heard of that happening.
Yeah. What if Article 1, Section 5 of the Louisiana Constitution is our state unreasonable searches and seizures? Couldn't we say, we're not going to follow the federal interpretation? We're going to make it stricter under the state constitution.
Well, the state can also.
And in fact, under the state constitution, we're going to say a warrant is required in every instance. Don't give me this stuff about plain view and hot pursuit. You serve somebody, you better go stop and get a warrant. Now, I'm not saying Louisiana would do that, you understand? And I'm not saying they should or shouldn't. They can do that, can't they, under their own state constitution?
They can provide more protection than the federal government. Yes.
Well, how can they get away with that under the supremacy clause? You got to go fast because Durbin's about to cut me off.
Yes, I'm sorry. How can they get away with providing more protections for people?
Yeah, under the supremacy clause.
Because it would depend on whether or not it conflicted with federal law. It doesn't conflict, I think, if the state provides more protection.
We call that the adequate and independent state ground doctrine, right?
Yes.
Okay. All right, I'm over, but only about 22 seconds. So I'm going to land this plane, and we'll take off again tomorrow.
Thank you.
Thank you.
This was a direct clash, John Kennedy versus Ketanji Jackson. Two visions of America, face to face. Welcome to Right Focus. Before we start, make sure you hit like and subscribe so you never miss a moment the establishment wants buried. In this exchange, Kennedy pushed Jackson in a way few senators ever do. He wasn't playing games. He demanded clear answers about how she interprets the Constitution. But every time he closed in, Jackson tried to slide away with vague language. It became obvious this wasn't just a questionnaire. It was a battle of worldviews. Kennedy stood firmly on the side of constitutional originalism, the idea that the law means what it meant when it was written. Jackson, meanwhile, leaned on open-ended legal language meant to keep her ideology vague. This wasn't accidental. The left wants judges who can bend the law to suit political goals. Kennedy's questioning forced her into a corner where she had to choose, expose her true perspective, or shut down. And that's exactly what happened. She shut down. The moment Kennedy demanded clarity on how far judges should go in reshaping law, she refused to engage. No specifics. No firm position. Nothing beyond carefully rehearsed talking points. It felt like she knew that stating her real judicial philosophy on the record would reveal her alignment with the activist legal movement the Democrats depend on. This confrontation matters because it shows what's really at stake. Kennedy was fighting for the Constitution as written. Jackson appeared to represent a model of judicial fluidity, a belief that judges can reinterpret the law as society evolves. That might sound harmless, but history tells us it leads to courts making law instead of interpreting it. That's how freedom erodes. The left understands this. That's why they rally behind nominees who refuse to define their positions. They want ambiguity so they can control outcomes later. Kennedy refused to let that stand. He pushed, he challenged, and he exposed the gap between Jackson's answers and the truth. It was America First constitutional clarity versus modern ideological activism. This was more than a hearing. This was a warning. If our courts are filled with judges who can't or won't define their relationship to the Constitution, the foundation of our republic weakens. Kennedy revealed that weakness, and Jackson's shutdown told us everything we needed to know. If you believe this fight matters, and it does, hit like, subscribe to Right Focus, and share this video. More Americans need to see that this isn't just politics. It's a battle over the soul of the country. Thanks for watching Right Focus. Stay vigilant, stay loud, and stay proud.